Can a foreign national, veterinarian, or other professional work part-time? Welcome to Live at Lunch with me, Emily Sumner from Sumner Immigration Law. Today we are talking about this question that we get quite frequently about: can a foreign national employee who is in the United States on a visa classification work part-time? The answer is yes, but, or maybe, but. And this particular question is especially prevalent in industries such as vet med or dentistry, or perhaps other industries where a professional like a veterinarian or perhaps a dentist may pick up shifts or per diem work at a practice other than the one that sponsored their visa classification. So let's talk about what this means to work part-time and what that answer means, the answer of yes, but, or maybe, but. So yes, but as always, this is not legal advice. You have to check with your immigration attorney. I am happy to answer questions to the extent that you have them, and to the extent that I can be helpful, I'm happy to help. But you do always have to check with a qualified immigration attorney to make sure that your decisions are not negatively impacting your immigration status. So in general, a person has to be, if a person is holding a non-immigrant visa classification, and when I say that, I mean a temporary visa classification like one of the letter visas, like for example, H-1B, H-1B1, TN, E3, things like that. They have to have work authorization, they have to have a petition, or they have to be sponsored, they have to be authorized to work for each individual employer. So let's take, for example, a vet who is working at Vet Hospital A in H-1B1 status, for example. So they're authorized to work at this vet hospital, and another hospital contacts them and says, hey, are you able to pick up shifts and to cover some shifts at our practice? It is not enough just because you are work authorized in the United States for Vet Hospital A or Animal Hospital A. That does not mean that you're authorized to work for any other entity. Again, it depends on your immigration status. We'll talk about some other situations as well in a few minutes. But just because you're here in a visa classification like H, like those ones that I said, H, E3, any visa classification, basically, you have to make sure that you're authorized to work for any particular job that you want to take. So again, going back to that example of the vet, let's call him John, who's working at Animal Hospital A, has an offer from Animal Hospital B. He's working in the United States in H-1B status, which is for citizens of Chile and Singapore. And he has this offer. What does he do? So he has to have an H-1B1 approval, a petition, or otherwise have an approval for Vet Hospital B to be able to work for that vet or Animal Hospital B. He can't just say, oh, I'm authorized to work for Animal Hospital A, so it's fine, I can go over here and pick up some shifts. No. And that's true even if the vet hospital is within the same organization. That gets complicated. Definitely talk to your immigration attorney, but there may be some additional steps that need to be taken, even if it's a different hospital or different location within the same overall organization. So make sure that you are work authorized. And again, it's not enough just because you hold TN status, for example, and you're authorized to work for Vet Hospital A. It does not mean that you can work for another vet hospital, because you have to have that permission to work for that particular individual employer. But you can do it. You can hold a classification, for example, H-1B, for example, or we've done it for H-1B1s, for E3s, for TNs, where they hold the visa classification for Animal Hospital A, and they also hold or have a valid petition, or otherwise have a valid permission to work for Animal Hospital B. Just as a side note, you have to make sure that you're reviewing your employment contract, or employers, if you're in this situation, you have to make sure that you're aware of that. There potentially could be non-compete agreements. I know that's been big in legal news recently, and I'm not going to touch that because I don't practice in that particular area, but make sure that you're paying attention to any sort of other compliance that you have to pay attention to. So we have had situations before where John, for example, is working for Animal Hospital A, for example, in H-1B1 status, and we obtain a second petition, basically, for him to be able to work for Vet Hospital B part-time. You have to specify, if a person is working part-time, you have to specify, A, that they're working part-time, And B, you have to specify the number of hours that the person will work at that particular place. If it's a visa classification like H-1B1, E3, H-1B1, sorry, I mentioned that, H-1B, H-1B1, which is different, E3, those three classifications require a labor condition application, also known as an LCA. You also have to have an LCA in place for that employer. That's part of the process of having a petition or a visa that allows you to work at that particular hospital. If it's a petition-based filing, in other words, if you're filing a petition with USCIS on that form, you have to indicate how many hours approximately the person is going to work if they're working part-time. If they're working full-time, it's not a problem. You don't have to do that. It is permissible to list a range of hours, but there's certain requirements that you have to meet, including paying them for a certain number of hours, regardless of what is listed there. There are regulatory requirements with Department of Labor that have to be met. So make sure if you are an employer in this situation hiring someone in a part-time position, make sure that A, you've I-9'd them and you have the proper immigration documentation, you have filed a petition, or otherwise they have permission to work for you. And make sure if it's a part-time position and you do have to file a petition with USCIS that you've indicated the number of hours that they're working and that you're tracking that. A, to make sure you're complying with any relevant employment laws. You have to pay them for the hours that are worked, of course, regardless of anything else, but there are also some other requirements that you have to meet immigration-wise. So make sure that you're coordinating closely with your immigration attorney if you're in that particular situation. But it absolutely is possible for a person to work part-time. There is no minimum number of hours that is required. That's a question I get frequently from employers. If you're filing a petition for part-time employment, it does have to be reasonable. And there's no, like I said, there is literally no minimum number of hours listed. But if you file a petition and say this person's going to work, 1 hour a month, A, is it worth filing that petition? But B, USCIS could question the legitimacy of that position. If it's really a position, or if it's just being filed perhaps to maintain immigration status or for some other reason. So look at the practicalities of the number of hours per week or month or whatever it is that the person is going to be working. The reasons you may have a part-time employment situation, it varies, of course, depending on the facts of the situation, but the ones that we have seen frequently over the years is a concurrent H-1B. We have a separate video on the concurrent H-1B, and I will try to remember to put the link in the comments if you want to reference that. A concurrent H-1B can be so H-1Bs some are subject to the cap, some are cap exempt. You can have a concurrent H-1B, meaning, we've done concurrent TNs, concurrent H-1B ones. So it is possible to do that, but that means that you hold, for example, H-1B status with that hospital A or animal hospital A, and you hold an H-1B status with employer B at the same time. And again, I'm using the example of a vet here, but this applies to basically any profession for which that is eligible for these visa classifications. It applies across all different professions and all different industries. So concurrent H-1Bs are possible. We've done a number of those over the years. Concurrent H-1Bs are also possible to do in a situation where a person is working for a cap exempt organization. So cap exempt means they're not subject to the H-1B lottery process. And that's a whole thing. We have lots of videos on that I'll reference as well, or that I'll link as well. But they are working for an organization that's cap exempt. They don't have to go through the lottery. They can also work concurrently at the same time for an employer who is cap subject without having to go through the H-1B lottery. They have to work for both entities at the same time, and they have to continue working for that H-1B exempt organization. They can't start that concurrent H-1B process and then say, oh, forget it, I'm not going to work for this cap exempt employer anymore. I'm just going to stay with this cap subject and not be subject to the H-1B cap. That's not going to work. That's not how that situation works. But we've had lots of clients over the years who have been able to work at otherwise cap subject employers without having to go through the lottery because they went through this process of having a concurrent H-1B with a cap exempt employer. It is possible other reasons that you may want to have a part-time H-1B is because a person has a side gig. It is increasingly common in this economy for a person to hold multiple jobs at the same time. Maybe both are part-time, maybe one's full-time and one's part-time. I've had run into situations where people want to have 2 full-time jobs. I don't recommend that for health reasons, but I'm not a doctor. That's not legal advice. But that is possible. Other times a person just wants to work part-time. Maybe they have responsibilities at home. They're caring for a sick person, whatever the situation is, and they want to work part-time. That is possible as well. I've also seen this work in situations where a reduction in the number of hours is an alternative to a layoff. So as you probably know, if you're in the immigration world, if you are laid off, you have a certain amount of time, typically 60 days, although there are exceptions, but typically 60 days to find a new employer and file a change of employer petition for whatever classification you're on. Again, I'm speaking broadly. This doesn't apply to every situation. But I've seen situations where the employer maybe says, you know what, I don't want to have to lay you off, or I don't want to have to furlough you. Furlough is a whole different situation in the immigration world. But it's an alternative to basically laying a person off and saying, okay, well, can you work 20 hours a week? In that situation, you have to file, if your person is going from a full-time position to a part-time position, most of the time, especially in the H-1B context, and other immigration classifications as well, you have to file an amended petition with USCIS to notify them that there have been what's called material changes to the terms and conditions of the employment. In other words, that they're going from full-time to part-time. And you, of course, as an employer, the employer has to pay the proffered wage. If it's a labor condition application based filing, like an H-1B, H-1B1, E3, they still have to meet the wage requirements, but you can pay an hourly wage and meet that wage requirement rather than paying a salary. So I've seen that happen before. And then, like I said, sometimes people want to have 2 jobs, 2 part-time jobs or a full-time and a part-time. So there is flexibility in this particular area. As I said when I first started speaking about this, it absolutely depends. The answer to this absolutely depends, and the process that you have to follow depends on your immigration status. If you are a person who is working in the United States on an EAD, employment authorization document, then it could be, again, this is not legal advice, so make sure that you talk with your lawyer. But if it's a person who is working, let's say that they have an H-4 EAD because their spouse is an H-1B and they meet certain requirements, so you're able to get an H-4 EAD. Or if your spouse is on a J-1 and you have a J-2 EAD, there are certain classifications like those where a person has an EAD, employment authorization document, and they're not tied to a particular employer. Or if you have an EAD, perhaps based on a green card filing, maybe you filed an I-485 and you have an EAD based on that. Those types of EADs are not necessarily tied to a particular employer, so you could have freedom to be able to have multiple positions or just have a part-time position without the restriction on the number of hours. One final thing to keep in mind in terms of working part-time as a foreign national vet or other professional in the United States is when you go through the employment-based green card process. If, let's say, you have an employer sponsor you for perm labor certification, which is typically the first step in an employment-based labor certification or employment-based green card process, unless you self-sponsor, that employment for the green card has to be full-time. You cannot sponsor a person for a green card, for an employment-based green card through the perm process for part-time employment. That doesn't mean that the employee has to be working full-time while all of that process is playing out. So the perm process typically takes a number of years from the time you start to the time you're able to get the green card. That doesn't mean that the foreign national has to be working full-time, it doesn't mean that they have to be working full-time for that entire time period. But as of the moment that the foreign national receives the green card, they do have to be working full-time for the sponsoring employer. And there's not much guidance about how long they have to be working, but you have to have a good faith intention. You, meaning the employer and the employee, have to have the good faith intention that the foreign national will work full-time in that particular position for which the perm has been filed. So I hope that you found this information helpful. If you have, please share this video with a friend or colleague. And I hope that you will join us next week for our Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world from our home base here in Richmond, Virginia, and other locations throughout the United States. We're all remote. So we're all over the United States and enjoy serving clients all over the US and from around the world with family-based and immigration and employment-based immigration matters. Join us next week, and until next time.